Hello, everyone. Thank you for joining us for our national webinar, which is a technical call that we do every year with the online form community. And it's meant to be a call where we tackle an issue that is common and that helps those that are beginning, intermediate, or advanced developers come in and get insight and resources and materials on from expert panelists like the ones we have in this call. So I'm really honored to present this with Mark Lauritsen and really excited that there was so much interest in this call. This call is going to be recorded and we're going to post it at probono.net LHI in the first page, but also all the call materials, the slides and everything will be posted in this folder so that others can use it or review it even after the call or if people miss the call. So as I said, we have a star-studded set of panelists. I'm really thankful for them to work with us in planning this for a little while. And so I will quickly go through what we're going to cover. What we're doing is we're going to talk about how do you take law and rules-based type systems and synthesize them so that once you actually create the online form, code anything, that tool and app at the end, all of that complexity and all of what's going on the back end, it's not evident to the user, and the user can sit down, make some choices, answer some true and falses, put some numbers, and at the end they get a super high quality, accurate, and complete document or tool or endpoint without them having to be doing a lot of the figuring things out. So that's the topic for this series, this conversation. And what we're going to do is this is the agenda. This is how conversation is gonna go. The call will probably go past past the hour. So if you can stay, that's at the end. We're hoping to have discussion, questions, maybe even sharing. So if you stay with us, it's going to probably, the panelists are gonna go past the hour. Just briefly about LawHelp Interactive, we basically have this vision that in the legal services world and in the access to justice world, there's a lot of complexity and a lot of stratification, and it is not easy to be a self-represented litigant or somebody that is a pro bono lawyer coming in to help people that need assistance with litigation or pre-litigation type document assembly. And so our vision is that the online forms are and will be a very easy to use resource, easy to find, easy to use, where somebody can sit down, do an interview, and assemble something that is very impressive, professional, complete, and where in the process of doing the interview, it will be a guided interview, and they will have support, assistance, and training so that by the time that they create their document, they know where they are in a position and they know what they need to do, and they may even get recommendations on what they need to do next. And so that's kind of the vision of LHI and how we focus our resources and attention to simplifying. LHI in a nutshell, we've basically been around since 2006, operated by Pro Bono Net, which is a technology company based out of New York. We operate with 47 states, and all those states do the same volume, but we do have multiple states that are doing more than 100,000 assemblies a year. And we work with all states, regardless of the size of their collection, supporting them and doing a lot of the other things we do. On a week, we on average do about 20,000 interviews a week, and from that, about 13,000, 14,000 documents a week are created for free by end users in LHI. The collection of content is about 5,700. Not all of them are used. The collection grows every month. Content is uploaded either to test or as final. And so it's like a river. It's coming and going. Some people are also doing deletion of all interviews or uploading new refined interviews. So the collection is pretty active and very significant. We work with multiple court systems, and right now we're working with New York State, California, Iowa, and DC courts as their online form solution, mostly in self-represented installs that now are remote or through self-help that it's online through well-designed, robust websites and other entry points into the access to justice system that the courts manage. In 2012, we were the first system in the United States to develop an XML to XML e-filing process using ECF4 standards, something that I don't believe anybody has replicated again. We are email submission and e-signature enabled, and that's something that has been really helpful as the pandemic has forced closures and filing places and things like that, so that those tools are in use and available right now through the interviews. And we integrate, we have APIs that different groups can work with us to integrate, and so that users can access the forms from other places or systems. And that could be something that's lawyer-centric or court-centric, like a legal server or Salesforce database used by Legal Aid or by Justice Center funded by DOJ, or in the end user example, like through partners like JustFix NYC, which is a very robust app that has been really doing tenant center work in New York City. We have a lot of resources. Our mission is to make sure that everybody that's doing online forms through LHI, legal nonprofits, and courts and their partners, that they have really great projects. So we focus on training so that if we increase everybody's capacity, the forms will get better and the user experience will get better. So we do a lot of one-on-one support. We provide technical assistance routinely. We routinely work with Capstone to review error logs in our systems, find forms that may or could be improved, and we have end user support where we're also monitoring if, qualitative information like, oh, these instructions weren't clear, or the filing fee changed, or even technical support issues like I'm on a cell phone and I don't know how to print. Our end user desktop helps with that. We participate in a lot of workshops and webinars and community calls, where people are talking about access to justice and the schism, and where online forms can, and we present a lot on best practices. A lot of projects are doing really neat and innovative work with the online forms, so we try to share best practices so others can replicate those. And then we work, with multiple networks that are national, etc. We do have monthly calls, and at the end of the call, I will share the information for our December call, which will be a technical call in nature. So lots of ways that we provide support, and of course, Miranda and I are always available if anybody needs to connect with us. I will transition now to Mark. That's it on LHI. Feel free to reach out if you have questions or want to learn. A lot of times our support is at the beginning very broad, and we can also be very, very focused and narrow. So Mark, I'm going to share the screen with you.
Sounds good. Thank you, Claudia. Good afternoon, everybody. This is Mark Lawrenson at Capstone Practice Systems in Massachusetts. And I've been trying to corral this amazing group of colleagues and friends to talk about a central topic. As soon as I get the presenter status, I'll share my screen, which I'll do now, and bring up my slides. And someone tell me if you're seeing my slides. I hope you are and hearing my voice.
Yes.
Okay, good. So very quickly, these are the panelists Claudia mentioned. We have Bart, Lori, John, Kevin, and Quentin. Again, some of the best people who have thought about and dealt for a long time quite deeply in these topics. We are explicitly and intentionally ecumenical. We're covering a variety of platforms. As some of you probably know, LawHelp Interactive itself primarily uses hot docs and A to J author as our authoring and delivery tools. But we'll hear from Neota Logic, from Kevin, and Quentin will talk about a variety of projects. I know he does a lot with DocAssemble, for instance. So the focus today really is how can developers on these different platforms deal with the inevitable process of converting complexity, complex know-how, rules, and strategic knowledge into well-behaving applications that ordinary folks, whether they're advocates or self-helpers, can use without themselves having to master and metabolize all that complexity. As you're doing that, what kind of formalisms work best for clarifying that? How do you represent it for your own sake as a programmer and for collaborating with SMEs, subject matter experts, before you go ahead and code it? And what kind of tools and techniques make the process less painful than it may have to be? I often bring up this example from John of a map of an A to J application showing the complexity that can lie in the logic of an interview, the connections between the pages one sees when you do an interview. In my own case, I was confronted with this challenge many years ago when I started working on a to J application for explaining UCC JEA logic, which is, of course, the Uniform Child Custody Enforcement Judgment Enforcement Act. And we'll hear about that in a couple of examples today. But just to show you, there's 9 of these modules on LHI which have that acronym in their title. There are probably many more that have the knowledge inside of it. It may look something like this, where you've got this is an old A to J4 style interview, where you've got a avatar guiding you through this complex landscape of information decisions. Behind the scenes, there's what could be a relatively simple map, in my case, of an application. This originated in the DC courts with Avi Sickle, who's here on the call, I believe. It was later transformed into one for California by Bob Aubin, who many of you know. And I had the job maybe 2 or 3 years ago of trying to document the knowledge here. And I went forth and I searched for explanations online about UCC JEA and found all kinds of colorful maps. And I just found myself wrestling with the complexity and not really succeeding. So with that introduction, I'm going to pass this to Bart, because Bart, I think, and Lori, who will speak after him, had the good experience of actually cracking this nut, I believe. So Bart, let me make you presenter, and feel free to start talking. And you are muted, Bart.
My mouse was not cooperating there.
Okay, we got you.
Okay. So what I'm going to show is an implementation of the UCC JEA logic that Mark referred to earlier in an online interview that is in the final stages of testing for use with Washington Forms Online. And the way we're going to approach this is I'm going to show you first the interview in action, and then I'm going to let you look under the hood a little bit at some of the coding. I'm not going to spend a lot of time on it. And then we're going to peel the onion a bit further, and Laurie Garber is going to show you how we got here. You know, how this knowledge about this pretty complex topic was actually transmitted to me so that I could make some sense of it and actually code it. And I like to think of folks who build interviews and templates as the construction company or the construction contractor. We need information, we need plans to be able to build these products or build the buildings, and then we need architects like Laurie who can supply the plans. And a lot of times we are working with folks who are subject matter experts who don't really give us a plan or a detailed plan, detailed blueprints of where we're going. We were extremely lucky in this instance that Laurie was able to provide that to us. And I think you will really be interested to see what she did as the basis for this interview. This interview is actually a divorce filing. and it produces a lot of documents and it deals with a lot of issues, but I'm just going to drill down on the children and jurisdiction over children. I'm going to go right to the children in this interview. And once we establish that the parties have minor children together, then we have this introductory screen, or part of the introductory screens, that helps us determine where we're going. And basically, we refer to this as, there are two paths, basically. We refer to them as the all-together path and the kid-by-kid path. So if people have multiple children, we need to make various determinations on a kid-by-kid basis. But in some instances, we can make decisions altogether. And then there's kind of gatekeeping questions here, which are basically questions about where the kids have lived. Interwoven with this UCC JEA logic is also questions about where the kids lived, because we also, in certain circumstances, have to collect a residence history for the children, what states, etc., they lived in, who they lived with, and so forth. And that actually gets woven into the, enters into the UCC JEA logic. So in the situation where the kids have always lived with the parents, they've never lived on an Indian reservation, they've always lived in Washington State for 5 years, and there's no custody orders, that's the simplest situation. The court has jurisdiction. Washington, in this instance, has jurisdiction to make custody decisions for the kids. So let's introduce some more complicated scenarios. So if the logic here is that if there are any custody orders for the children, then we go into the kid-by-kid handling. If there's no custody orders, but for some reason we need to, let's say they haven't lived in Washington and they have always lived together, let me see. We collect all the information about where they lived in the past and the jurisdictional questions, which you see down here at the bottom. We collect all that information on one screen. Let me show you the more complicated situation, which is they have not lived together, and there's a custody order. And either one of those will trigger the kid-by-kid logic. So I'm going to go to the child, jump to the children here. Okay. So a lot of information we're collecting about each child, but down at the bottom here, we're collecting information about where this particular child lived. And we are also collecting information about jurisdiction. So let me just I'm going to unanswer. I want to unanswer, if I can, some of these questions. Unanswer this one, unanswer this one. And all these questions, of course, are required. And I'm going to close, I'm just going to make this a little smaller. So first of all, we're collecting the information about where they lived. And then we ask about a custody order. If there is a custody order, then we go down the path of asking questions about the custody order. And each answer here triggers, actually triggers another question being asked. So in this case, we know there was a custody order. The custody order was made in Alabama. And then we ask, is the child in Washington, is Joan in Washington now? Is this child in Washington? We have another question. Each of these questions is in a logic tree. And if we say no to this question, and the child has been in Washington at least 6 months, we get a conclusion here that Washington can just take home state jurisdiction. And that conclusion will be reflected in the final document that generates. There's also a question about temporary absence that doesn't change the outcome. I'll say there's less than 6 months here. And then I'm asked if there's an emergency. I'll say no. And the court may, in this instance, we're giving the user a warning, the court may not have authority to make a parenting plan for this child. And we're explaining why. And this is a pretty complicated situation, so we're telling people they should go and talk to a lawyer. If we also went in a situation where we're telling them there's no jurisdiction, we're also giving them the option to override the logic. In other words, they can say, you know what, I understand that maybe there's no jurisdiction over this child, but I'm going to override that, and I want to see if the judge will approve it anyway. And I gather that there may be circumstances where that actually will happen because, for example, the other parent may agree to have jurisdiction, that the court can take jurisdiction. So I'll say there's an emergency, and I get the conclusion that the court can take temporary emergency jurisdiction. Go to the second child, and it's saying there's something unanswered here. Let's see what it. Let me say, I'll say no to custody order here. And it's picking up the answer here as to where the child lives. I guess what the problem is.
I think, yeah, it's your unanswered is lived with.
Yeah, okay. And I'll just finish this interview. There are no other required. I'll just, for the heck of it, I'll save it. And I'm just generating the petition here. And if I go to jurisdiction over children, whoops, it's probably not the heading. It'll be better if I just go down to section 7 where it appears. And you'll get a look at the actual form when Lori talks about it, but you can see that we've checked off the box here for jurisdiction. We've checked off also the basis for jurisdiction here, and it differentiates between the children. So there's temporary emergency jurisdiction over Joan, but for Bart, we have a conclusion that the court doesn't have jurisdiction. I'm going to close this and just briefly show you some of the logic under the hood. So this is the kid by kid logic, as we call it, and it is the most complicated because it deals with a situation where there is a custody order. I'm going to go to the script of this dialogue and show you what this logic looks like. So this is where it begins, and there is a logic tree, and notice how it's indented here, because that'll have some significance later when Lori talks about this. You're going to see how the logic, she originally represented this logic. There are basically two big tracks here. One is if there's a custody order, and then there is a situation where there's no custody order and we just look at other factors. And in the template itself, the logic, again, I'm going to have to just navigate down to that. Every checkbox here in the jurisdiction over children has a computation, hot docs computation variable that determines whether or not the box should be checked based on the original logic in the interview and the information the user has provided. And that's basically a very quick overview, a very complex set of logic to deal with. And the, that's the view from the construction contractors in the construction contractors world. So I can, at this point, ask Lori to take over and show us how we got here.
Great, thanks, Bart. Happy to do that. Let me just make sure that I'm showing the right screen here. And there we go. You all seeing pretty colors?
Yes.
Yes, beautiful.
All right. This represents the fuzziness of the UCCJA and how people's eyes cross when you see it and are trying to figure it out. So I'm Lori Garber, and I am a longtime legal aid attorney at the Northwest Justice Project in Washington State. And I come to this work, I'm currently the project manager of the Washington Forms Online project that's automating our family law forms here in Washington. But I really come to this from the perspective of 20 years of serving clients and litigating family law. So I'm a project manager and subject matter expert rolled into one, and have somewhat reluctantly over the last couple of years become a programmer as well, under the tutelage of Mark and Barton and Willow. So with this tackling this logic behind the UCCJEA was a real challenge, though, because this is something that lawyers and judges struggle to understand and is really overwhelming, I know, to clients, as I've worked with folks on this over the years. So, for starters, we're representing an incredibly complex statute. It's a uniform law, so it's in most all states in some form or another. Fortunately, in Washington State, we've already, as a state, gone through a process of plain language conversion of our mandatory family law form. So there'd been a real effort made to simplify the language of the UCCJA into the forms that people need to fill out as much as possible. But I can tell you from working with folks in clinics and talking to court facilitators that people still get to this section of their form and just are stumped and overwhelmed. It's long, it's complicated. What does it mean to have exclusive continuing jurisdiction? So all the plain language in the world can't save you from a really complex statutory scheme. So when we needed to add children to some of our interviews, and I'll say this UCCJA logic is actually live and in use in our domestic violence protection order interview that includes children. And it's in the testing phase in the divorce interview that Bart showed you, and will go live soon, but this is in use now in our protection order interview. So the real challenge is, how are we going to get people through this hurdle? Because, I've seen interviews and looked at other examples, and we could just, present people the options on the form and have you make your best guess at what you think applies, but that's not really very helpful and doesn't simplify anything for the user. So I asked myself, how do I figure this out? What do I ask a client when I'm trying to figure out whether or not I've got jurisdiction over a child, and just started writing down in no particular order, what are the questions that, what are the facts that I need to know to make the conclusions that I make knowing the statutory scheme. And so I gathered my list of questions and I looked at other examples, and then I just started writing them down. And I started in a Word document, and I tried working backwards from the forms and thinking about all the different ways that could get me to a certain checkbox in the form, and I just wasn't finding it helpful. And I'm a really visual person. So what I landed on was an Excel spreadsheet that just mapped every question and shows the logic tree. And so this is the structure really that Bart was showing you in the back end and the script of the dialogue, that the way the logic branches starts with a question, and then, you know, essentially, you know, here's your opener and here's your else statement right here. And what I found is that when I mapped everything out, and it let me, and I put the questions down there, it let me simplify, because I could see when I was repeating a series of questions, and then I could move things around so that I could only ask them once and get the broadest questions first. So this is really, I mean, this is the final iteration and the simplest one. It's 43 lines. The longest branch is 7 questions. My first draft was 115 lines with the longest branch at 12 questions. So it took a lot of time and effort, and also other lawyers who know the UCCJEA checking my work to make sure that I hadn't missed something and or gotten something wrong. But it took a lot of work to simplify it, but what we ended up with something relatively clean and straightforward, and that was easy to program. So the way this works is really, it's just a stair step. It starts, every column, it represents a question and its possible answers. So the question is here, has a judge already made a custody order? And then you drop down to either yes or no, and then if it's yes, then you move right to the subsequent question. Where was your child custody order made? And your options are Washington, or, you know, the drop down has all 50 states, but if it's not Washington, the logic will treat it the same. So Washington or other state. If it's Washington, you move to the right. Does this child still live in Washington? If yes, you move to the right, and now you've reached a conclusion. This is a fairly simple path. There is a Washington state order, kid's still here, Washington still has jurisdiction, we're good to go. And so the way this works is you know, it's just down and to the right. However you need to go to reach various conclusions. And because I'm visual, everything's color coded, green or red, and I tried to keep things yes or no questions as much as possible. There is more complexity in that some branches are slightly different. If you are in the filing interview, starting your case versus the final interview. And so I have a longer version of this spreadsheet. It's I think 60 some lines, that includes the finalized version of this or variation on this logic. But it also helps us see, you know, what is exactly the same in the filing scenario and what's different in the final scenario, and map it all out. And I flagged emergencies yellow, just so I could see if I was unnecessarily repeating things or if I really needed to get to those conclusions differently. And then also every conclusion that's up here in white or yellow, as the case may be, all these child juror 1, 2, 3, 10, 11, 12, blah, blah. All of these are, you know, the endpoints, the conclusions of the logic. And so, you know, I have a shorthand title, so I don't have to write it out really long, and then wrote out for Bart, you know, here's what I want this to say. And then told him what the template consequence would be. You know, if we land at DE1, then I want you to check this box in the template. Or land at 2, I want you to check that box in the template. And then, of course, the final step is mapping it back to the form. So, this is our first order checkbox, and conclusions 1, 4, 5, 7, 9, 15, and 17 are all yeses. There is jurisdiction. And 2, 3, 6, 11, and 18 are all no's, so they're going to make you check that you cannot approve. And then, of course, all the sub ones. So this way, there was really no question for Bart about what the template consequence would be at the end of each branch of this logic. And as Bart showed you, we did have some gatekeeping questions, and related to child custody jurisdiction is where the child have lived over a period of time. Washington has a requirement you disclose a 5-year address history if there have been basically anything complicated, like living outside of Washington or living with someone other than the parents. And because we knew that sometimes we would only have one child and sometimes we would have multiple children, and we'd need to know if those multiple children all live together. We put things in a truth table to figure out how we would need to gather the information, if we could do our all together track, or if we needed to go kid by kid. And also if there were some simple paths where we don't even need to go down the road. And so that's that first simple path that Bart showed you, right? We don't need the 5-year address history. We don't care if the kids have all lived together because we don't have to go there. There's no custody order, that's false. So we don't have to ask address history, and we already know we've got home state jurisdiction. We don't even need to enter the logic tree. So this also helped guide the programming and figure out, which scenarios needed to go on which dialogues and down which roads we needed to go down and when and how. And so my final nugget is that the best conclusion, or the best way of handling complexity is if you can avoid it altogether, right? If there's a shortcut, or if there's a way that you don't need to go down a road, try to offer that up first and do those quick screening questions, so that in certain situations you don't even have to make the user answer all those complex UCC-JAA questions, because they have a simple and really common scenario, which is what we allowed for here with our early gatekeeping questions. So that's all from me.
Thank you, Lori. I know folks are going to have questions and comments. I'm seeing some in the question pane. We'll deal with them after we get our presenters all in. I hope we've also satisfied you that this is incredibly complex. Even the end result is maybe more complex than we would like, but we're doing our best to simplify it. Let me give John the presenter status, and John, you're it. You can talk about how A to J these days deals with these challenges.
Cool, thanks, Mark. By the way, Bart and Lori, that was awesome, and there's so many things that I could say about that, but I have a big slideshow, although not a lot to say, and I'll try to refer back to that. So hi, my name is John Mayer, Executive Director of CALI, Consortium of Law Schools, developers of A to J Author, and I really wanted to start with the fact that we're trying to code decision trees, and there's decision trees everywhere in the law, right? You can call them flowcharts, choose your own adventures, or an expert system. Sure, this is an expert system. And the output is some sort of guided interview, chatbot, interactive assistance. That's the interface that the SRL might see. So I was really caught by Mark's small little sort of like a second title here, turning complex legal know-how into well-behaving applications. And I could give an hour talk on both those sentences, but I'm going to keep it really short and try to cover the complex legal knowledge aspect. So there's a lot of complex legal know-how in the law itself, right? And if I had a law and order theme here, dun dun, you know that the law itself is hard, and audit and coding that, there's been lots of attempts and lots of discussion about law as code, or is it algorithm, or doing natural language processing on that. although natural language is certainly not the same as law language, trying to get better or different legislative drafting so that the complexity, if it starts simple, then it's easier to automate, right? But then there's always the problem of, well, what do they intend from that legislative drafting? And all I'm saying is, when you start looking at coding the law, there be dragons. So I grabbed a Komodo dragon as my example here. And a lot of what we're doing with A to J author is aiming at, and the original intent of the project was to aim at low-hanging fruit. In other words, less complex things. It's a short. The short thing I want to say is, we felt like there was enough automation work that was simple, and that if we did that, then we would be accomplishing an awful lot. And we did a study last summer where how much of that low-hanging fruit has been actually automated, and the short answer is about 20%. And so it's wonderful that people are doing complex projects, and they're necessary, and I'll demonstrate why they are necessary a little bit further. But there's plenty of work for people to do that doesn't involve getting too complicated or as complicated as all get out that the law might provide. All right. So the other side of complex legal know-how is in the brains of smart people, of subject matter experts, and in this case, mostly legal aid attorneys. And the fact that their brains have to be all over the place because there's jurisdictions all over the place. I didn't have enough time to copy the books and the brains into every single state, so this is all you get. And representing that complex legal knowledge that's inside the heads of people who are experienced in the actual practice. And I'll get to why the actual practice is as important, if not more important, than the law itself. So we represent this as a tree, or it's funny, when we talk about decision trees, they should actually be upside down, right? Where you start at the top and go down. So maybe it should be called decision roots or something, but I won't go into that. And we're looking at a path that takes you down the major branches. And the major branches are chosen because they're the most likely paths. Lori mentioned, if you might want to front load your interview, your guided questions with things that take you down the most likely path so that you're not wasting the time of the user. This is a big deal with us in A to J Author. We train our authors so that they ask disqualifying or guiding questions up front. If they're in the wrong place, don't have the information, or whatever the reason is, then get them out of there, respect their time. You might also say that you want to choose paths that are easier to automate, or the easiest to automate. This is what I meant by low-hanging fruit, because they're quicker, they're cheaper. And maybe there's, and this is not always true, but you want to automate the ones where there's the least consequence, where if you make a mistake in the law or in your automation, and this is software, there's going to be mistakes, that there's chances for them to fix it if something goes wrong. There's also thing about less complexity is that the experts, have more confidence in lower complexity things, or they have more confidence in areas and they've practiced longer, and that plays into what they're willing to attempt. And finally, there's ROI, pure return on investment. I've got this amount of time, I've got this amount of money, I've got this amount of expertise. How can I get the most bang for the buck for my value, right? So this is my bold statement: complexity of assistance. In other words, the subject matter expert's knowledge of the domain and not necessarily the law is more relevant than the complexity of the law. And there's actually a book on this called Administrative Burden by Hurd and Moynihan, in which they basically say a lot of times the government or the courts or people in power design things to be hard to use. And we saw that starkly in Florida this year when it was admitted that the applications for unemployment system, was designed to be hard to fill out and designed to reject people more than it was to accept people, because the state didn't want to spend the money. And so I highly recommend this book. It's kind of thick, but it's a great read about all the reasons why there's complexity in civic tech and legal tech. You know, and at this point, I just got to reference Lori's statement. You know, all the plain language in the world cannot, cannot simplify a complicated statutory scheme. So I think it's hopeless to hope that the law will get so simple that anybody can read it, at least in the near future. That doesn't mean we shouldn't keep pushing in that direction, because it needs to go that way. But man, it's a long path on that. So the other aspect of this is that whenever you're building your decision tree, you're going to also decide not to automate some parts. You're going to trim the tree. You know, the rare, unusual things that don't happen, the things that you could triage out. Oh, this aspect of this problem is handled very well by this group or this other form or this other place. You know, so you turf them out to someplace else. Or as I saw in part in your form, you know, if it's too complex, well, then bail. You know, this needs a lawyer. All of this is because there might be some administrative burden or some systemic complexity that just makes it impossible to automate, right? So getting the knowledge out of the lawyer and into the decision tree, but in A to J author, it's not the same thing, right? That tree and the example that Mark showed might be a path of the process in which form filling out is only a part of that, or form filling out is not the entirety of the legal process. And so when I'm talking about A to J author, I'm not talking about legal processes. I'm talking about decisions that have to be made for the production of a particular document. Now, grant you, there are sometimes legal decisions in there, right? If then else's that are at the forks of the path that decide one way or another, you know, whether you're eligible or not eligible, or whether you fill out this form or that form or such a things. So there's some congruence, there's some equivalency between the process and the decision tree that you might find in a guided interview. Now and this is just to illustrate that on the left side is an example of a flow chart for a legal process, and on the right side is a flow chart for making decisions about filling out a particular form that may or may not encompass the entirety of a legal process. So back in 2005, we had A to J author. We used Flash, and because Flash was essentially a graphical user interface in of itself that ran in any browser, we were able to do what we called the mapper. You know, we mapped out the person's journey. In 2020, we still aren't back to the level of what we could do with Flash, partly because it's harder to do in JavaScript. And we've been, you know, distracted or interested in other things. But with our new mapper, you can do a lot of editing right inside the mapper. You can add new pages. You could draw a line from one question to another, and that automatically creates a link. When you click on a particular question, up pops the detail of that question, which you can fill out. And the goal here was an attempt, and I'll admit, we haven't gotten there yet, but an attempt to prevent what Lori was doing with Excel spreadsheets. We worked with lots of lawyers who did exactly that. They worked in Word or Excel or Post-its or Lucidchart or MindMeister, you know, and then they did a lot of cutting and pasting or backing and forthing and stuff like that. And we were seeing if we can start the process of building all that capability as simple as possible right into the tool itself so that it simplifies the process. We're not quite there yet, but we're definitely closer with the new iteration of the mapper. So the goal is to make the subject matter the author of the guided interview. This is 15 years of experience speaking. That's a failure, right? When we started out with A to J author, we thought we could train lawyers, and we can in about 2 hours how to use A to J author. But the reality of it is most of the projects have hired someone, or Lori has, or people like Lori have come along and said, well, I'll learn the tool. Now, in her case, she's maybe she's an example of a success, right? She's both the subject matter expert and the quote unquote programmer of the tool, although she has to work with Bart to do that. And that's true also with A to J author. We often have to find somebody who is quote unquote skilled with A to J author. I hesitate to call him a programmer, but what else would it be, right? You know, but our goal was originally that the lawyers themselves, the subject matter themselves, would be very close to the tool itself, so that we could compress that activity and make it as fast as possible. I love this chart from Hello Divorce. It shows, it's user friendly, it's SRL friendly. And it's perfect because it also shows a sort of a you are here. You can see where you are. And how interesting is it that it also has the UCC JEE, right at the top there. We didn't plan that, right? And so our thinking going forward is that maybe the mapper is an alternative interface for the user. So they can see a sort of a you are here. Now, in this case, it doesn't look very helpful. So maybe it would be more something like this. Our you are here right now with A2J author. The design of this interface is to be as simple as possible, as undistracting as possible. We know that self-represented litigants are stressed and English is a second language and so on. And so, the you are here is obvious, and then the path that you're on is also obvious. You're going down a path right in the user interface, right? In this case, maybe instead the you are here would be stuck right on the screen, sort of like the equivalent of Google Maps or those video games where you've got, like, in the main screen you see you walking with your weapon and shooting aliens, and then in the lower screen you see the map of everything you've seen. I don't know if you've ever played Doom or Quake or something like that. They were really good on that. Anyhow, let me finish up by saying that there's a constant danger here in all of this, and it's the expertise bias. Is that we design interfaces, but we're all smart, techie people, and the people we're designing interfaces for are not. They are not familiar with technology. I know we think, oh, everybody's got a smartphone, everybody uses a web browser. Not as much as we do. And so we always have to gear back our expectations, because they're struggling not just with your interface, but also with an unfamiliar area, something that's going to cause critical danger or problems to their lives. And they have to get through it, in a way that, it's just the stress. I can't imagine how terrible it might be. So we always have to be careful of our expertise bias. So that's all I've got to say. I could talk for another half hour on well-behaving applications and what that might mean, and I'm not going to do that.
Oh, please. Thank you, John. That is spectacular as always. We could obviously devote an entire day, if not a week, to the topics you've touched on, but we got to keep moving. And I'm going to make Kevin our presenter. He's going to switch us from A2J land to Neota Logic land and talk about how this plays out in that world.
Hey, Mark, can you hear me now?
I hear you.
Okay, great. Thank you very much. Let me just move over here to the gallery. And I think you can see my screen. Is that correct?
We see your screen and we see a gallery.
Oh, excellent. So slideshow from the beginning. Can you see the large screen that says Idea Gallery?
Yes.
You're seeing.
All right, fantastic. My name's Kevin Mulcahy. I'm with Neota Logic, which is an expert system platform, and we sell the platform to large law firms and to legal departments so that they can build their own expert systems. And we started it quite a while ago, probably ahead of our time. But we're so pleased that the world has moved in our direction, and we've got a lot of interest. It used to be that people would say, oh, a robot lawyer doesn't sound like it's something we can trust, but people realize automation is so key. And it's great to see so many people doing this with different tool sets, because it has to be done. We're 100 years behind the curve here. People who are good at the hard sciences, engineering, they figured out ingenious ways to mass produce products in a beautiful way, efficient way. That was the first industrial revolution. Now we're finally getting a chance to do it with all this white collar work. And it's fascinating to see how it's working. All of us on this call are in the boiler room. We're making the things, and we see what the challenges are. And they are significant, because the law's challenging. And then whatever tool you're using has its challenges too. So you got to master both. And we're just always trying to make the tool easier. And we've realized over the last couple of years that what we need to do is step back and not focus only on teaching our particular tool, but show law students and others, hey, how do you even break down the law so that it can be programmed? So that's the theme of our classes in various law schools. And people are pretty into it. The DNA of lawyers is very similar to the DNA of programmers, we have found. So they're reticent, they're receptive rather. When we go into a law school and say, hey, we're going to show you how to diagram the law, think about the law as a programmer or engineer, we're not asking a tiger to change their stripes. It's what they're instinctively can do and want to do, but just have never really had tools to do it. And we're never expected to do it. And those are the big changes. So the type of apps that we tend to build on this platform are listed here. All various forms of advisors, some with a central theme on intake, some with a central theme on producing a document at the end. But a lot of them just ask questions and then give advice in a very short report. These quick answer advisors, they're my favorite because they're really the closest thing to replicating an actual lawyer. You're really trying to take on that subjective judgment. So we have a lot of these being done in our law school classes. And I just wanted to point out that there's such a difference in size. The small ones we call cupcakes and large ones wedding cakes. They all use the same ingredients. So once you're good at your cupcake, you probably can move up, but you got to go in with your eyes open. Otherwise, it'll take too long. Just to give you some ideas here, here's a small app on a very narrow question. Can you use that music in your programming promotion? On the right, you see it's just one issue, 5 variables, 1 conclusion variable. So simple. A student can get their head around that in half an hour. And then once they do, they're off to the races. But the key message we try to give is, hey, it's legal tech, but my gosh, it's so much legal writing. It's so much counseling. It's so much of what we traditionally think of lawyers doing. It's just on steroids because now you can produce 1,000 memos at once. And the question is, who among us in this profession can step forward and write all this stuff down and get it in a way that people can program it? That's the challenge. That's what we've been seeing in these presentations so far. So here you see a whole new class of advisors that are available to people now if we have the people to design them and build them. And since it's a new field, as we find things that work, we're starting to write them down and helping people learn what might work for them, what would save them the difficult times that we've had in the early days of diagramming these projects or planning these projects. So let me just skip forward. Obviously you're not able to take all this in. This PowerPoint is available to you afterwards if you're interested in it. But the point of it is just showing the oceans of opportunity ahead of us. If we can do these in a way that is efficient and then transparent and speak for themselves, improve themselves. And now these calculator advisors are among my favorites. Here on the screen, you see the report, which is giving you the number. Okay, we determined the number to be 6 million, et cetera. But most importantly, here's how we got it. We're showing the math. And this is something we really emphasize with students is, look, if you show the math, you're going to win the case. The judge is going to grant your motion in 10 minutes if you want to show how, what the alimony should be or what the child support should be. Build a system that doesn't just bring out the number, but shows every single step. And then it helps you sleep at night because any mistakes in your logic will be revealed through this. But in order to do this type of work, we have to find people that love to work with variables and conditionals. And there's a lot of them out there, and we're slowly finding them. These paycheck checkers are really important, as well as this one, which I love, done by students in Arizona. It calculates the cost of eviction for a community, whether it be a nation or a neighborhood. And the true cost of eviction is much higher than you might think because it involves court system costs, it involves emergency room costs, homeless shelters, et cetera. And these students prove how high that cost is. So people like current Congress people can use this to be educated. So it's an exciting field if we can produce these things. So what I wanted to really focus on in this short time together is tips for planning the content. That first initial step. Here is what we typically go through. We have the preparation phase, the building phase, and the deployment phase. And the preparation phase is definitely the most important. The people with the most experience, the highest paid people should be really all over that preparation stage. And then once they do that, they can step back and they can have other people fill in the blanks. So we'd like in this presentation to focus on some tips that we've developed for this preparation phase, which might take these periods of time. Okay, so let me jump out of this, and I want to go to another PowerPoint. I'm going to do slideshow from the beginning. Hang on, actually escape out of that. Okay, Mark, let me just ask you, are you able to see this pretty clearly?
Yes, we are.
Oh, great. Well, what we help the students work through is the challenge of the blank slate. They have a lot of energy at the beginning, but they realize, oh my gosh, how am I going to pull this together? So our tips are to, number one, define the app clearly with a subtitle like this. Can the direct shipper sell to a reseller exempt from sales tax? That forces you to sharpen the focus. There's no question about who this app is for. And then imagine working with content experts, and you extract from them what the potential scenarios might be. So you're starting at the end. You're not saying, hey, what questions might you ask right at the beginning? But it's like, where are we going with this? And the content experts often will come with sort of the broad categories like this. And what we ask the students to try and push and say, hey, that is good start, but what are the specifics? So the app might not be applicable for these particular reasons, or the exempt sale would be for these particular reasons, and the non-exempt would be for that. And it is at this moment that the app sort of comes to life. This is like the moment of conception when the content expert says, oh, wow, I never thought of it that way. But those 6 bullets is really the waterfront for us. We really do put everybody into these buckets. And once you have buckets or categories like this that are defined, the engineering becomes a lot easier. And as a writer, I'm so excited because I can start to picture what I'm going to write for each of these buckets, or what I like to call them is scenarios. They are scenarios. They show my endpoints of reasoning, but they also show how I got there. And I want to know how I got there. The medium is the message. So often students will just say, oh, you're exempt, you're eligible, you're not eligible. And I'm like, come on, what's the story? Why am I not eligible? Why am I eligible? And they're like, oh, okay. They thought that was kind of a detail to do at the end. But if you bake the pathway into your thinking about the structure of the app, it becomes a lot easier to build. So here we now have the analysis figured out. We have our overall flow defined. We're good to go. This one little PowerPoint screen allows us to budget the time on this project, know who should work on it. It allows us to go off and start writing. And we're not going to make a lot of changes because it's been so nicely defined. So let's look at another example. Here, the nexus question. Well, some people might think, it's either you have the nexus or you don't. But if you push those content experts, you'll usually find particular reasons for no, particular reasons for yes. And that's gold. And this might take days to do because you really got to know the law. You got to know the practical value of these scenarios. And it's up to the content expert, which is why we call these expert systems, to make the decision. Is 7 scenarios going to cut it? And if they say yes, you run with it. Now I can build a system from this. I can make my decision trees, whatever they are. I can see the questions I need. I can see the rules, and I can see the outputs. All there, just from these 7 bullets. Now, I put a framework around it, and I can hand this off to our teammates who can spend more time filling in the blanks in the content document. And this works even when there's a lot of complexity in the app. So the point here is to look at a very high level, to find a way to see the forest without getting into the trees. Here, this California residency advisor has basically 5 buckets, but to get to those buckets, there's a fair amount of complexity, but that's okay. We're ready to handle that at the next stage. What we want at the beginning is clarity at a high level. Complexity compartmentalized and at the lower level is fine. The law has that, we got to deal with it. But at a high level, you want to try to avoid the complexity, and this is pretty good. This is just basically 5 buckets. Either the person's underage, so we're not going to continue the analysis, or hey, you are a resident in California for this particular reason. You have a low tax year presence in the state under 31 days in the tax year. You're in. Or you're a non-resident because you have a low 3-year presence, which is you're in the state fewer than 300 qualified presence days for 3 years. Now, what are qualified presence days? That's defined elsewhere. And we'll get to that, and we'll have math that figures it out. But what's important at these early stage is to just get the buy-in from the content expert that this is sufficient. Once they do, this app can be built pretty quickly. But it really takes someone who knows the law, knows this space, to be confident to say those are the 5 big categories. Once you do that, you're good. This one PowerPoint is a ticket to efficient building over just a matter of days rather than a lot of iterations and trial and error, which often happens with software projects. And even when there's multiple issues. Yeah.
We need to stop.
Okay, great. I think we're just about at the end. This is an example of how it goes for multiple issues. You know, you lay out the 3 issues, all with the granular endpoints, then you show the relationships among them and finish up with the process. So that is basically the gist of what we are teaching in the schools. And then, you know, we give them the no-code tool set that we have, and they're able to make these apps. So I'll wrap it up there, Mark.
Excellent. Thank you, Kevin. Yeah, the no code theme definitely comes out here, and we all look forward to that possibility. Let me pass it to Quentin to wrap us up today. Quentin is another fellow academic who has labored in these fields, and I'm going to make you presenter, Quentin, and you can take it over.
Great, thanks, Mark. All right, let me just go ahead and share. I have a couple of slides, and I'll do a really brief demo because I want to make sure to save some time for everybody's questions. So let's start with just these couple of slides that I'm going to run through. So my name is Quentin Stainhouse. I'm at the Legal Innovation and Technology Lab at Suffolk right now. Before that, I was at Greater Boston Legal Services for about 12 years, where I built some of these user-facing apps. Is everybody seeing my screen? Just want to make sure.
Yes, we see it.
Okay, great. Had a little border before when I was testing to make sure it was still the right thing. All right, so I think we've touched on a lot of these themes, so I won't belabor the point. But maybe some of you are still wondering, like, why does this all matter? Why do we want to try to think of ways to represent rules and code in ways that lawyers and programmers can both understand? And I think that in addition, just having everyone speaking the same language is a piece of it. And when we do get people to speak the same language, we're able to reduce errors. We do a better job of making sure the code actually represents the rule as the expert understands it to be. And we have the ability to speed up changes as well. None of these applications are static or should be static. Law changes. We might start with that small scope, as John really correctly pointed out, like starting with the smallest piece that you can do is a great way to make sure that you reduce errors, but maybe you have funding and time and a commitment to expand the scope later. So the more you're able to represent those rules in a way that's clear and easy to understand, the better your chances are being able to do that continual updating process, which is really important. Here's one way for us to look at that. And that the big theme that comes out there is, how do we encapsulate the law from the other things that our application is doing? Because there's a lot that it's doing. It's talking to the user, it's explaining. We might have some code that shows logos and certain text that's not really about the logic as it applies to the legal rule. But that has to be represented somewhere. So the more we can encapsulate that, so it's more like pressing a button and getting back an answer when we do represent the rules, the easier it is for us to interact with it and make sure we do it in a way that doesn't break as we make changes over time. So one of those models of abstraction that comes from computer programming, it's been around for a very long time. And there's lots of other ways to think about this separation of functionality, is this idea of model view controller. That's one of the oldest types of ways of thinking of those separate functions. So you have an interface that the person interacts with. That's the view. You might have buttons that you can press, like the big one green button we had on the previous screen. And then underneath that is your model, and that's representing the actual rules and behavior and the information storage of your application. By having each of those a clear path between each of those separate states, you're able to better isolate changes to one area so they don't affect the other. So how do we encapsulate code? I think for the most part today we've heard a lot about representations that are useful as internal, not as internal representations, but to help you get towards the actual representation of the code. I'm going to talk a little bit more about how you would actually use these to drive the logic of your application. So we have some situations where maybe we're writing computer code in the form of functions. That's really great encapsulation. Give me these two pieces of input, give me back an answer. We have decision tables, and Lori was showing how those were used for really great effect in the UCC JEA, but as an intermediate state, right? So before we could translate it into computer code, we might write it into a decision table. And then finally, there's a graph or flowchart metaphor. I tend to stay away from the graph or flowchart metaphor for the most part because of that lovely slide that John Mayer had posted on Twitter a while ago and that Mark shared at the beginning of our presentation. It can become unwieldy when you have a lot of complex logic, but it can be a really useful intermediate state. And if you have the right scope of what you're trying to represent in a flowchart, maybe that's the best solution for representing it. So each of these three methods can be used to drive the real flow of a guided interview that's producing some kind of advice or output at the end. And when you have that ability you design these in such a way that your subject matter expert can understand and interact with them, you have a better chance of doing that accurately. Here's an example of what a function that represents a legal rule might look like. And we spend a lot of time thinking about no-code solutions, but text is one of the most powerful and flexible representations of knowledge that is in existence, right? So we can read it and understand it as long as the scope and the interface that we have to that code is clear and that the names of the variables that it uses are clear. And we're using a language that makes sense in a relative sense. There's not like a lot of distracting elements to it. I think HotDocs scripting language is relatively straightforward to understand. And I think what A to J author does, this happens to be Python, which is what drives the docassemble environment. But again, if you just look at this, you can actually see what's going on and understand this is implementing the rule correctly or incorrectly without having to really be a computer programmer. This is an example of a truth table, or decision table rather, that's used to drive the logic in one of the interviews that I've been working on for the last few years and have kept updating. And it was really powerful to have a representation like this in order to drive the logic because it has continued to be updated over the last 2 or 3 years. What you see here on the left are various claims or defenses that someone might raise in an eviction case. Column B here shows the values that I'm looking for. And then on the right, it shows a discovery request that gets made in the final output document. And what I realized is that it was really going to be a big time saver if we combined the functionality of producing an answer, a written answer with claims and defenses, and have that generate the relevant discovery that went along with those claims and defenses. That would be a really big time saver for our attorneys and users. So here's what that looks like in action. That table that you just saw is actually loaded by the DocAssemble application in real time and used to do the selection of, I've gone through and I produced a bunch of claims and defenses in this interview. I can go in and customize and see what discovery it thinks is relevant for my case. And it comes from that truth table there. So this is mostly meant for more advanced users to customize. We don't expect many tenants to do this on their own, but you can see it's checked off a number of relevant interrogatories and document requests based on what I think are the claims and defenses that I have in my case. Let me go back to the slides here. Now, the last technology I think that's pretty interesting to look at, and that actually is being used really fairly widely in the business world, is business process modeling and notation. So this is a diagram using the BPMN standard. And what you'll see is this is a kind of a model scenario here. But it's a flowchart, right? It looks fairly easy to understand visually, and it has a small defined scope. But large companies like airplanes, the airline industry use modeling, process modeling, and using BPMN specifically to actually drive decisions that are made by frontline workers for things like, when should a refund be issued? Any kind of decision like that where you're asking someone to make it and you want it to be done in a reproducible way. If you can model it in something like BPMN, you can have a person execute it because they can follow a flowchart. You can also have a computer follow it and execute it like a flowchart. So this is the kind of work that Singapore Management University, they're working with this type of a subset of BPMN, the decision modeling and notation format, and they're implementing that in DocAssemble as well. So I think the challenge there when you do decide to move to a flowchart is, again, having it representing a small piece of the logical chain at once. And again, that goes down to encapsulation. And how do you encapsulate the problem that you're trying to solve correctly at the right size? So to me, I think the most important thing when you're designing these as a programmer is making sure that you follow those good practices of isolating your business rules from the display and template logic, because each of those three places are going to have some logic that's involved. But the more that you can keep the legal rules isolated and with a clear interface, by that I mean things like the name you give a function, the name that you give variables. So that's very clear and easy to see for someone who's reviewing your code what your intention is. The more that you follow those patterns, the better off you're going to be at being able to correctly and repeatedly represent legal rules in a way that can be updated, maintained, and be accurate and correct. And the context that we're living in here, right? We're zoomed in on this little part of the automation world, which is legal. But if we zoomed out, we would see the whole world is dealing with these kinds of problems, and legal is just one small subject expertise area in the wider world of computer programming. So when we're looking for good practices, we should remember that and look out towards the computer programming world and some of the practices that they've come up with over the years, and try to use those as well. And a big piece of that, in addition to what we talked about, there's lots of good practices that you can follow, things like using testing, for example. We didn't touch on today at all, but that's an important part as well of making sure that your rules are represented correctly. So that was a quick whirlwind, but I'm going to stop there to make sure that we can get some questions for all of the panelists.
Thank you very much, Quentin. lots of wisdom and food for thought in that presentation too. I mean, I love the idea of what some people call executable specifications, where you have some representation of knowledge in natural English or something that a non-programmer can understand, but then the computer, the application, can actually directly manipulate and build its interface from it. So that's very promising. We just have a few minutes left for reactions. Let me, while I'm looking at the questions and asking anyone in the audience who wants to raise their hand or be unmuted, let me ask our panelists if anyone wants to say anything or ask anything of each other. So Kevin, John, Bart, Lori, anybody want to react to what we've heard from each other?
Mark, can you hear me?
Yes, Kevin.
This is Kevin. I loved all the presentations, especially Lori's, because I just felt like such a kindred spirit. We really should compare notes, because sometimes you feel like you're out there doing something on your own, and it was exciting to see somebody else doing something very similar and overcoming some of the same challenges. And I think the theme for me is this is coding for lawyers. No, it's not traditional computer code as we use that term, but all of us used color coding. All of us use abbreviations. All of us are doing that kind of work so that the process can be automated. And we just have to keep pushing the industry to understand that that kind of coding is appropriate. So legal writing courses just have to be expanded. They have to do the type of writing we are doing, which is more of a code-based writing.
It's a great point.
Claudia or others want to?
Yeah, I was gonna say that's a great point. Is that law schools really do need to update the exposure and the skills of because law graduates are not necessarily all going to be lawyers. Look at us, right, in this call. So as we think about the future and what technologies and tools will be used in legal services, in pro bono, and in other spaces, in the access to justice space, which could soon be seriously privatized, we need to be exposing people in law school so that they can have the skills to join other, multiple career paths, and no longer think that it's only about the blue book citations and like the jurisdictional statement and all the stuff they teach you and all of that. So Kevin, that's actually a really great point. I know some of us here are involved in academia, so definitely something to keep pushing forward. There was a question up for Lori that I think if it could be summarized correctly is in the chat. It was, how does this interact with Washington RPC's rules of professional conduct in creating a legal conclusion? And so Lori, any thoughts on that, on how you use your judgment to figure out, okay, when do we get to this conclusion and when do we not? Because I know that you use your judgment as somebody that's represented people, but also as an expert in the forms and process. How did you balance that?
Yeah, that's an interesting question. And I think we're kind of kidding ourselves if we don't think we're reaching conclusions. Anytime we decide to show or hide or make a branch, we're directing a user and making choices. I think it looks a little bit more explicit in this UCCJA context because, we say, oh, it looks like, Washington has home state jurisdiction. And I will say my first draft of that sentence was Washington has home state jurisdiction. And I went, maybe it looks like Washington has home state jurisdiction, because what I'm trying to do is, I think it was Kevin or, I'm not sure which one of you said it, but to show my work, here's why we reached this conclusion. And I think that's also why this is not legal advice. This is us showing, with these inputs, this is the output, and it is just a representation of the rule. And yes, it took my legal knowledge to create that, but it's reflecting back how why it reached the conclusion that it made. So, you know, it's you know, it looks like Alabama had home state, but no one, you know, you said no one lives there anymore, and that, you know, therefore Washington, it looks like Washington can take the jurisdiction. But I will say we also decided, you know, it wasn't in my original draft, but decided to give users the override that Bart showed at the very beginning, in part because what if, you know, maybe someone misunderstood a question or answered it not quite correctly, and so they reached the conclusion based on the answers they gave, but that's actually not correct in their situation. And so it's sort of an escape hatch. You know, here's what, you know, according to the inputs you gave us, here's the conclusion that the application reaches, and we're telling you how and why we got there. But if you want to override this, you as the user can. In case your life, your decision to make. So even though, actually, I want to clarify, you actually can't consent to UCC JEA jurisdiction, but, you know, it may be that you shouldn't, you know, that something was not quite correct in the answers, and you want to get it, throw it to the judge, and the judge will decide, and that's okay. But I will say, I think we're more comfortable doing this as a legal aid organization. I know some court based programs are a little more conservative on these lines.
Okay, I see two folks that have either raised hands or posted questions. Are you okay if I go on and unmute them, Mark?
I see we have one from Nell Escher in the question pane first, which is about testing methods. And maybe we could ask Quentin to quickly talk about what testing methods you use for your programs. Do you create automated test suites, unit functional integration testing? Do they guarantee full coverage? Quentin, maybe a quick answer to that cluster of questions.
Yeah, that's touched on some meaty issues there. Yeah, I would say that what we're doing is, first of all, we try to use something like Kevin's scenario-based testing. So we try to create scenarios like that when we have a finished application, and then we design tests that cover those scenarios. So like for a typical smaller interview might have 5 or 10 scenarios, and we just, you know, walk down the path to get to the end and make sure that we can do that correctly. And we try to do a matrix that covers all the really important branching points of the form and make sure the scenarios, while realistic, cover each of those important points. And from that, we do try to use automated tests as well, once the form is stable enough that it makes sense to do, because it is fairly rigid. So we're writing tests using a platform called Cucumber, which, you know, it's a computer essentially that simulates moving around a mouse and clicking inputs. So it can be used with any of these platforms. A2J Author, HotDocs, or Neotologic could all use the same method. You write your you write what you want it to do in kind of a plain language form, like then I click the button that says next. That's what you would literally write in the test, and then it will run it. And that really helps with catching regressions, because none of these forms are static. You're working on it, you come back, you have to add a new feature. A week later, does it still work the way that it did a week ago when you changed the thing that you thought wasn't related? Well, an automated test is really helpful for you to catch that. As soon as you push up your code to the server, the automated test can run and it can tell you, actually, you broke it. And you don't have to go through that exhaustive testing manually. If you have the automated test that runs each time, it really helps you and force you to test it quite a bit more than you otherwise would.
Thank you, Quentin. And maybe we could have a last comment or question from Sarah Kubik, who asked to be unmuted and raised her hand. You got the floor, Sarah.
Hi, can you hear me?
Yes.
Awesome, thanks. So I'm Sarah, I'm near Chicago, I'm a lawyer, I have a strong interest in technology. And one of the things I realized is, and I'm gonna ask it to anybody, we use technology and we could just click, 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 click so quickly. When you talk to a lawyer, if you're a client, it could be slower, it's a much slower process. Have any of you developed some sort of way to get the user of your systems to slow down, because what they're doing is important, but once you understand how to click here, click here, click there,
Right.
maybe they're glossing over the information, is my question, kind of.
Who wants to answer that? Maybe John Mayer?
I'll try two answers. One, that's why with A to J, it's only one question per page. It seems to slow down the whole process, but it actually creates more accuracy and actually speeds it up because there's less confusion. And the second is, there have been situations where we've worked with authors where we said, if this is a really important threshold question, ask it twice in two different ways. And then if there's inconsistency, then clarify it before moving on. It means a lot more, sort of steps, but if it's that important, then don't get it wrong.
I think we need to leave it
Absolutely.
there. Kevin, quickly get a quick word in, please.
Oh, we actually call them speed bumps, where we ask an important question and then they give the answer, and then we give it back to them and say, did you really mean this? Yes. Speed bumps.
Yep.
Cool. All right, we could go on and on. I want to thank our panelists and our audience for your patience and attention. This will be recorded. We'd love to keep the conversation going in various ways. Claudia, back to you if you want to wrap up with anything.
Yes, I will wrap up just inviting everyone to our last call of the year on the 15th at 2 p.m. We, in LHI, like I said, we have thousands of templates, and the majority of those are available to download and review and analyze to see if the techniques and what's going on in the front language, but also the output and what's in the middle, all the in hot docs, all the component files in A to J and all of that, see if that can be used for another similar project that has similar law or a similar approach or problem area. So on the 15th, Mark and Bart are gonna guide us on an approach on how to use those interviews and how to walk through them and do your due diligence to see if it will make sense to use what you found that's from another state or another developer, or how to walk through somebody else's work. So hopefully this is something that is of interest and it will be recorded also. And so just sharing that, but wanted to thank everybody. You will be getting an email asking for some feedback. And if all of you can answer the email, it has like 5 questions. That would also be great to hear what you thought of this this panel and everything that we discussed. So thank you for joining us.
Bye.
Thank you.
Thanks, everybody.
Thanks.
Bye.